Good morning, this is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for November 6th, 2024. All matters being heard today in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nanez, would you call our first case, please?
Yes, ma'am. Calling cause number 2024 DCV 1336, Miguel Antonio Marquez on behalf of IM minor child versus Tiana Gomez Arredondo. Announcements, please.
Bobby Ramos on behalf of plaintiffs.
Good morning, Your Honor. This is Sebastian Uribe on behalf of the defendant.
And we're here on entry of judgment. What are we waiting on? We had the hearing on this one. Is this the one where Mr. Herrera was the ad litem?
That's correct, Your Honor.
So, what are we waiting on? Did we have the ad litem fee resolved? Was that part of any proposed judgment? Have you sent us anything?
I don't believe the ad litem fee was an issue. I mean, we sent over the checks to Mr. Ramos's office on October the 8th. That's what I'm showing here. Is that correct, Mr. Ramos?
Yeah, that's correct. We've received the checks and everything is good to go. I don't know about if there was any issue as far as the guardian ad litem or anything like that. But as far as I know, I think everything was resolved with him.
Ms. Hernandez, can you tell me if we received, I remembered a brief report from Mr. Herrera. Did we only receive the report or did we receive something in addition to that with respect to the fee?
Let me check on that, Judge.
What about the documents? Let me go back. Let me look up your cost number. Were the funds going to be put in the registry of the court?
Yes, Judge, they're going to be put in the registry of the court.
And did you all provide the documents for the district clerk on that?
No, Your Honor, we haven't done that yet.
So what's the holdup?
It was my error, Your Honor. I'll get it done this week.
What else was outstanding?
That was it, Judge, from what we have.
That's my understanding as well, Judge. That I don't know if you were looking for the fees for the ad litem fees, it was $1,111 with 25 cents. That's the number we all agreed on.
Good.
Yes, ma'am.
The report was sent from Mr. Herrera to the court.
Mm-hmm. I have it. I just looked through my emails. I actually had not read. I remember. I'm going off of memory is basically what I'm saying. So let me go back and look at something.
Judge,
Yes.
just give me 1 second here. I gotta set something up.
Oh, okay. Thank you, Mr. Cherboga.
Okay, Judge.
Thank you. Yeah, okay, so I'm going to reset this for 2 weeks. Please get me the documentation in terms of orders on the ad litem fee, the investing or placing the funds in the registry of the court. I still haven't received those. Thank you
Yes,
very
Your
much.
Honor. Thank you, Your Honor.
Thank you, Judge. May I be excused?
You may. Who's next?
Page 1, Judge.
Mm-hmm.
Calling cause number 2024 DCV 4289. Announcements, please. Ms. Nava?
Sorry, I was trying to unmute. Good morning, Your Honor, Alyssa Nava on behalf of the expungee, or the petitioner. We're actually moving for a continuance, Your Honor. My client is not entitled to it until July of next year. We went ahead and filed it. The county attorney's in agreement as well.
Okay, so you're asking that it stay on the docket and just reset it for after July?
Yes, Your Honor, so that way, once he is entitled to it, we'd agree on the order.
Is there someone here from the county attorney's office? All right, we'll go ahead and reset it. Thank you very much, Ms. Nava.
Thank you, Your Honor.
Okay, who's next?
Page 3. Calling cause number 2023 DCV 2566, Robert Williams versus Cynthia Garcia. The announcements, please.
Good morning, Lauren Spencer and Yvonne Trevino with Sandoval and James for Robert Williams, the plaintiff.
Jose Vega here on behalf of the defendant, Judge.
Good morning. Final civil pretrial. How are we doing on this case?
Your Honor,
Judge?
plaintiff is ready.
Oh, go ahead.
I'm sorry. But there are pending motions, I believe, in front of the court.
Had you all requested hearings on those?
These are, Your Honor, there are no motions. The only motion that plaintiff has on file is in response to defendant's motion. I believe he has a continuance as well as a motion to strike. And then we filed a response with a motion to for leave on the motion to strike.
I see a motion for leave hearing set December 4th. That's at the docket call. But let me go back. I don't see that the motion for continuance or the motion to strike were set for hearing. Mr. Vega, those are yours. I'm trying to, let me see, where are you? There you are. Okay.
Yes, Judge. And other than that, it's just waiting on records. One, I do have a conflict of setting with this case that is supposed to go to trial a few days before this accident. I mean, a few days before your trial setting, and I apologize for that, Judge. Right now, it looks like it's going to trial. We're already set. It's an older case in this one. The claim rep and the insurance company are still pretty far apart. But I mean, I never know if cases are going to settle, Judge. But that one is set for trial. And I think it said, like I said, just a couple of days or a few days before this one. On this one, our biggest impediment right now in relation to the defense side is when we received medical records, we received the medical records that were related to this accident. And for some reason, there was an extra MRI there. The MRI relates to his last visit with the chiropractor, I believe, was on November 15, 2022. We received an extra MRI ordered by a Dr. Lovato on July 17, 2023, and we didn't know what that was. So at his deposition that we took just in July, I asked him who Dr. Lovato was. He didn't know who this doctor was, but he thinks that it was someone that referred him from the VA. And that's where he told us that he still continues to treat for his problems related to this accident because of the VA. He also acknowledged at his deposition that he has pre-existing problems relating to his back. Whether those were treated by the VA, whether they were not, I don't know. So what I did whenever I took his deposition, we boarded records from the VA. With the VA, you never know when you're going to get those records. I mean, I don't know if I'll have them in time for trial or not. And that's the reason for the continuance. He got an MRI at Southwest X-Ray. We boarded those records. And then he also says that he continues to treat for his car accident, with the VA. I always have a question in interrogatories asking if they continue to treat. I was told that he wasn't, so I didn't worry about it until his deposition. And that's what my delay is on this. In relation to the motions, Judge, it just has to do with affidavits and reasonableness and necessity. What happened is all the affidavits were filed in this case, and we filed controverting affidavits regardless. Like there's controverting affidavits out there. So my understanding of, the Civil Practice Remedies Code, the plaintiff's going to have to bring someone to substantiate the reasonableness and necessity in relation to the medical records. We only filed a motion to strike. We have a controverting affidavit in relation to the referral to
Pain
to
Relief
the,
Center?
yeah, the pain relief center. So we have a controverting affidavit in relation to the referral to that provider. But we didn't do a controverting affidavit in relation to that treatment. It was just a referral. And the reason we didn't do it is because it wasn't timely filed. So that's the reason for the motion to strike. So all those issues are basically issues. I would say they're more evidentiary issues when the plaintiff's attorney decides to present, their affidavits for reasonableness as necessity. We do have controverting affidavits in relation to all that. So that's where we stand, Judge. The continuance is not sought for delay. I need those records from the VA. Like I said, I didn't know that he had continued treating. I didn't verify it until his deposition, and we're just kind of, holding off for the VA to see exactly when they provide them, and I just don't know. So I think on the continuance, I asked for 90 days. I believe that should be enough, Judge. I know that my paralegals continue calling the VA just about every day asking for those records. And that's kind of what you have to do with the VA and records and getting records from them. So that's why I filed a continuance, Judge. Like I said, I've got a conflict of setting. I apologize for that. It seems like everybody kind of set me for trial, and which I like because most cases settle out in November or December. But this one, the one that's a little bit older than this one hasn't settled. And so it looks like I might go to
Did you go to
trial.
mediation?
Yes, Your Honor.
Judge.
May I respond to him just so slightly to discuss the motion for continuance?
Yes, ma'am.
Thank you, Your Honor. We did have my client's deposition in July. Right after, in August, we did supply defense counsel's office with a medical authorization to go ahead and get those records. We had a mediation in September, reached an impasse, and it wasn't until October 1st, I believe, that we received notice of any DWQs going to the VA or this X-ray facility. So ultimately, I understand when these records are requested, way back when, and they're not coming in time. But this is something that was done only after mediation failed. And in terms of the motion to strike, I guess I'm just needing some clarity from defense counsel here. In the event that, we want to present these bills and records, we understand that you've controverted them and we will bring a doctor to go ahead and testify. My concern is that if, we then immediately upon receipt of those records supplemented those and filed a motion for leave for the same. And then designation of experts came, we went ahead and listed everyone, and there was no response in terms of defense appointing or designating any experts to refute those opinions. And so we just want to ensure that we are going to be able to have an opportunity to present these records. But of course, in terms of reasonableness and necessity, we'll have a doctor to opine on that.
Okay.
Yeah, Judge, I think the record's getting it. It's just the charges that Chapter 18 addresses. And just briefly, I have interrogatory question number 12. I mean, everybody does things to save on expenses. My question reads exactly like this. Which of the physicians and or healthcare providers identified in interrogatory number 10 is still treating you for injuries claimed in this lawsuit? None. And then we take his depo and we find out that he's still treating at the VA. That's what that MRI, that inadvertent record that was sent to me relates to. And so we did go to mediation. I ordered those records when the case didn't settle. I don't think that I wouldn't fault myself in any way for relying on their answers to interrogatories and then attempting to settle this case before incurring the expense of the VA. It's really hard to get records from the VA. I was hoping not to do that. I was hoping that the case would settle. But like I said, when they tell you in answers to interrogatories that are verified that they're no longer treating, and then you take their deposition and you find out that that answer is incorrect, it puts you in a very difficult situation. This is the first continuance, Judge. I just need those records. And like I said, we do have a conflict of setting in relation to trial, but I don't like to use those conflicts of setting, Judge, because I'm always set for trial.
Mr. Vega, what's the other cause number? I didn't see that in your motion for continuance.
It was in place. It was in the conflict of setting. The other one is, let me see.
Just to be perfectly clear about the VA records, Your Honor, there was a military injury that our client discussed in his deposition in 1980. There was an incident 10 years ago, a motor vehicle collision that he treated with the VA. And specifically, his ongoing issues with the VA are mainly with his knees, which is not a injury claimed in this lawsuit. He discussed back, hip, and shoulder and neck injuries for this particular incident, the subject of this lawsuit. And then I believe that the extent of any kind of treatment has been medication with the VA. So I just wanted to make that perfectly clear.
Okay,
Judge, and he said something different in his deposition. I mean, he said under oath that he was still treating for this accident. I could show you the transcript.
So
I
wait a
even
minute.
asked him.
Here's what we're gonna do, a couple of things. So first of all, the motion for continuance, and then, let's see, the motion to strike was filed in October, on October 1st. I don't know that we were given the heads up in terms of an email saying I filed this, judge, and either a hearing or I'd like the court to consider it. So just looking at it now, I'm seeing that this is filed and I see the response, but it is not set for hearing today, and I think I want it set for hearing. I also want the motion for continuance that was filed on November 1st to be set for hearing. And we're gonna do that, let me see, we have the, what was the December 4th motion for leave? Let me see.
And I'm supposed to be in trial December 3rd in cause number 2022 DCB 0181, Judge. It's Garcia versus Chavira. It's in the 448th.
2020 what?
2022 DCB 0181.
Let me look at something. It's a jury trial?
Yes, Judge.
They do have a panel. Okay. Here's what we're gonna do. So the motion for leave, oh, where is that? I did not see that motion. Let me go back.
Yes, Your Honor, that was so that we would be able to file the affidavits regarding the billing and medical of the Pain Relief Center. They were due in December of 2023. We filed them and served them to counsel in February of 2024. And it was in response to the motion to strike.
Here's what we're gonna do scheduling wise. We're going to bump up the motion for leave hearing to coincide with a hearing on the motion for continuance, the motion to strike. I see there's a motion in limine, so we might as well talk about that then as well. It's gonna be November 20th at 11 a.m.
This is Mountain Time, right, Your Honor?
Correct. We'll do it at 11 a.m. Oh, yeah, we'll do that. Everything else will stay as is. And we'll go from there. I will throw out there, no, I'm not gonna throw anything out there. We're gonna leave it at that.
Understood, Your Honor. Last question for you. This will be via Zoom as well?
Correct.
Thank you.
Unless you all request something in person, we'll do it via Zoom. Okay?
Thank you, Your Honor. May
No,
we be-
Judge, and what happens if, like, for example, my continuance is no longer necessary? Because I just need those records 14 days before trial. Let's just say that my case on the other one does resolve. Could we remove the continuance and only do the motion to strike?
I'm gonna set it, and if you no longer need the hearing or want to withdraw your motion, you can let us know.
Sounds good, Judge. I appreciate that.
Thank you very much. Thanks, guys.
Thank you.
If
Thank
you don't
you.
have anything else, you all are excused. Thank you very much.
Have a good
Thank you,
day.
Judge.
Take care. Mr. Nunez?
Okay, page 1, Judge. Calling cause number 2021 DCV 1635 Gerardo G. Garcia et al. Versus Bernie R. Acevedo. Announcements, please.
Good morning, Your Honor. This is James Fuel on behalf of the plaintiff.
Good morning, Honor. Lisa Hayes for the defendant.
Good morning. Let's see, final civil pretrial. I don't want to get confused. I feel like I had a dismissal, but maybe it's not your case. What's going on in this case?
Plaintiff is announcing ready to go to trial on December 6th, I believe, Your Honor.
Okay. All right, Ms. Hayes?
Your Honor, I had asked Mr. Fuel if he would agree to take a late deposition, and he was not inclined to do so. Because it is so embarrassingly late that any trial preparation is being done for this case, I hesitated to ask the court for leave. It's been pending for a very long time, but quite frankly, not a single deposition has ever been taken in this case. And so I did think in preparation for trial, that would be worthwhile and it wouldn't take much time. But Mr. Fuel indicated his opposition. So without the opportunity to take that deposition, I would prefer to proceed with the depo before we go to trial, but I will defer to the court.
Well, I don't really have anything here, Ms. Hayes, for me to consider. So if you want to file something and whether it includes a lot of things, a request to have the court consider a deposition, continuance, whatever it is, please file something, but email it to Ms. Hernandez so I can get it set quickly for hearing because the timetable is going to be a little tough, right? Yeah. So beyond that, we'll just proceed as is. If there's something that you need the court to consider, just send it to Myrna and make your request for a hearing. So I'm alerted that something is filed, okay?
Will do.
Thank you, counsel. Anything else, Mr. Fuel?
Nothing further on this case, Your Honor.
Thank
I
you.
think I have a 10:15, so I'll stick for that one.
Okay, thank you, Ms. Hayes.
Thank
All
you,
right.
Your Honor.
Who's next?
Page 2, Judge.
Mm-hmm.
Calling cause number 2022 DCV 0886 Eduardo Cabral et al. Versus My Universe Inc. et al. Announcements, please.
Good morning, Your Honor. It's Brendan Villanueva here on behalf of the plaintiffs.
Carlos Rincon for Landstar.
Sebastián Uribe for RV Share.
Dan Hernandez on behalf of My Universe and Kushbal Singh.
Good morning.
Morning.
So technically we're scheduled for a docket call. I think I missed you all last time. Okay. Well, I did miss you all, just so you know.
Okay.
What are we doing? What
Your
are
Honor,
we doing? Are we setting a new trial date?
Yes. So on November the 8th, the court, the Honorable Suzanne Larson, heard a motion for continuance that had been filed by several parties. It was not filed by the plaintiffs or by Landstar, but by other parties. And Judge Larson, after considering the motion, granted it. And so at this juncture, there have been some settlements, but we still have the plaintiffs, Landstar, and it looks like RV Share are still in the case. We need a trial date so that we can work on a scheduling order. One issue that came up that your court coordinator indicated she was unaware of, I anticipate, based on the number of depositions, that this case will have approximately 40 witnesses. There are a large number of plaintiffs, and what we were trying to do is calculate the length of the trial. And so the way I looked at it, if every witness only testified for 1 hour, that's 40 hours of testimony. Some of these witnesses are going to be half day, 3/4 of a day. Some might be an hour, but most of them are going to be 2 or 3 hour witnesses. So realistically, Your Honor, I'm thinking a 3-week slot to try this case, but it is doable. We've been working extremely hard. Me and Mr. Villanueva are attached at the hip pretty much every other day doing expert depositions. And so right now it's just a question of trying to slot it in. If it could be done, I think a preferential setting, given you got out-of-town counsel, out-of-town witnesses, and it just
has to be a special setting. Absolutely.
Yeah. So that's it. That's exactly where we're at, Judge.
If I may, Your Honor, real quick.
Yes, sir.
All right. I can't speak for obviously the other parties, but what I can say, Your Honor, is that for the plaintiff's presentation, that means our direct examinations, cross-examinations, things like that, we are anticipating we can get all that done within a week. And I understand that the court sets these trials on Friday, so I'm assuming that we could maybe hit the ground running on Monday or sometime during that day. I would think that we could get it done in 2 weeks. And when we had our hearing last time, the coordinator said, 2 weeks is the maximum amount. I don't know if you have 3-week settings. I can't tell Carlos how to do his case or anything like that. But what I can tell him is that just for the plaintiffs, we would only need a week, which would, I think, allow him and the other defendant a whole week as well, right, for their time. So I think we could get it. We could have a jury discussing, deliberating after 2 weeks. I'm not sure if it requires 3 weeks, but I just wanted to let the court know that's sort of our position. And seeing as the court doesn't really do 3-week settings, if that makes it also easier scheduling wise, we can tell you that our part, the plaintiff's part, we can for sure get it done in a week.
Your Honor, may I just fill in one fact?
Mm-hmm.
There have been approximately 12 witnesses that have testified through an interpreter. It is inconceivable that you're going to get through. There's going to be approximately 8 to 10 witnesses that the length of their hour and a half, 2-hour testimony is going to turn into 4 because it's Q&A and English. And then there's English, Spanish, and then there's 2 witnesses that speak a foreign language, my universe, Mr. Hernandez's clients. And so just on that alone, it's going to add a factor of days to the translation. And I know because all these depositions have taken multiple hours.
Mm-hmm. Yeah, no. The 3-week, the 3-week, 4-week doesn't, that doesn't bother me. It's just a matter of where that means you fall in the scheduling. And so Mr. Hernandez is telling me that July 18th is open. July 18th is a Friday jury selection, and that we might be okay for a 3-week trial there.
That works, Judge. That works.
I'll tell you this, I bet it's going to go shorter because you don't know how hot the courtroom gets in the summer. Nobody's going to want to be in there. You all are going to be asking your questions like this. But if that date works, let's set it.
It works for Landstar, Judge.
We're available that date, Your Honor. If there isn't any earlier date that could be provided, we can be available on that date.
I'm surprised that July is open. I mean, when I've been talking about resets, but of course it's mostly criminal. I'm talking about September. So.
In Your Honor, on behalf of my clients, my universe and Kushpal Singh, we are working out a settlement agreement. And so we might not be part of that party in July.
Okay, well, we'll miss you, Mr. Hernandez, but.
On behalf of RV Share, July 18th works.
Okay, let's set it. Myrna, we need to specially set it. Mr. Nunez, do we have, and let me look. Do we have?
We have 120 in Commissioner's Court.
Beautiful. At the very least, it'll be cooler.
Yes.
Commissioner's Court, I think.
Would we only do jury selection in Commissioner's Court, or we do the whole trial?
Just jury selection. Unfortunately, unless I can have some miracle with facilities happen here that hasn't happened in 6 years, we're going to be in trial in a warm courtroom. It just happens. But jury selection, it's way worse in the courtroom in the summer. So we'll have the larger space and then be in our courtroom. Is there something that doesn't work with the courtroom, Mr. Rincon?
No, it's all good, Judge. It's all good. Thank you.
Myrna, let's make sure we have notations about the remainder of our dockets for that window. We need to make sure it's specially set. And that way, when we get a little bit closer, we don't have anybody saying, well, but I have them over here and all those things.
Yes, Judge.
are you all asking for a new scheduling order based on this new trial date?
We'll probably need some new deadlines. We can work it out. We've worked very well together, Judge, and we're continuing to work through all this.
Then I am going to put a scheduling, entry of scheduling order hearing in 2 weeks.
Okay.
So you all can submit to the court whatever agreed order you all have come up with this new date. And then I don't think I want to set anything other than a final civil pretrial a month before the trial setting, just to check in with you all.
Sure.
Okay, and I will rely on you to let me know if there's something that you need in the interim. But you know, you all have been really diligent, so I'm not going to try and take up a lot of your time.
Yes, Your Honor, there's going to be Dalbert hearings, I think, on both sides. So we'll get that set up.
Okay.
All right.
Anything else?
No, Your Honor, that's it. May we be excused?
Everyone good? Yes, you may.
Yes. Thank you very much. Good luck, Judge. Have a wonderful afternoon.
Thank you.
Take care.
Thank you, Your Honor. Have a good rest of your day.
You too. Bye-bye. All right. Who's next?
H3, Judge. Calling cause number 2022 DCV 0441. Joel Science Flores versus Mario Hector Hernandez et al. Announcements, please.
Jeff McElroy on behalf of the plaintiff, Joel Science Flores.
Cliff Jessup for defendant, Progressive County Mutual Insurance Company, Judge.
Okay, final civil pretrial. Give me
Yes,
that.
Your Honor. Actually, this is an interesting scenario we are in. You might recall at the last final status conference, Mr. Kavanaugh's client was ordered to appear for deposition, and he was supposed to appear on October 30th. However, Mr. Kavanaugh, and he telegraphed this to the court last time, that he was probably going to be in a non-cooperation situation with his client. So we had him notice for deposition. Mr. Kavanaugh tendered his policy limit a week before the deposition. Now, one thing we did not want to get into was having the witness no-show on that deposition and set up their non-cooperation defense and have it possibly affect the uninsured motorist coverage as well. So what we had agreed to, and I don't know if Mr. Jessup remembers this or not, we were going to abandon this scheduling order if we settled with Mr. Kavanaugh, and we were going to set up a new scheduling order. Now, just yesterday, I got from Mr. Jessup a plethora of controverting affidavits, which is now 30 days before trial. This means, of course, as Mr. Vega said earlier when he was talking with the Sandoval and James people, I've got to get my clients' treating doctors now to either come forward with deposition dates, or I've got to bring them live at trial. Additionally, I may want to take the depositions of the controverting affidavits. I've not read them in detail. I don't know if the qualifications under 18.001 are met. They usually are. Mr. Jessup usually has quality people, but I don't think we can be ready for trial on this December 13th trial date 1 month from now, because I also still need to take the deposition, and this time I'm going to have to put him under subpoena, but without the risk of non-cooperation. I still need to take the deposition of the defendant driver, because we have video of him at the accident scene where he opens the door to get out of the truck and beer bottles fall all over the cab of the pickup truck. So I still need that deposition. I wanted to talk to Mr. Jessup and tell him he didn't need to panic on his controverting affidavits. I believe we just need to do a new scheduling order. It gives us a little time to do discovery, plus now get a mediation going on UIM rather than a mediation going on third party, where there was a potential Stowers situation that we let go because of how afraid we were of the non-cooperation issue.
Judge, and if I may, Progressive was actually abated from this case with an order signed in December 6, 2023. According to the terms of that abatement, we're back in this case once co-defendant Hernandez is either non-suited or settled. And so since we know there's a settlement, Judge, under the terms, I think we're unabated. So that's why I filed those a bunch of pretrial motions and everything yesterday in the event that you do want to preserve the December trial setting. With regards to the controverting affidavit, Judge, if you read those, because those are actually filed by Mario Hernandez's counsel. They were filed by him a year ago, timely. Since he's going to be likely dismissed from this case, I moved to ask the court to let me adopt those, and that's why I filed those, and that's in the motions. But all of that was in anticipation of if the court does not continue the December trial date. I would agree with Mr. Muckleroy. Now that we can narrow down the UIM issues, I do think it'd be beneficial to, like he said, depose Mr. Hernandez in that context under subpoena. There would probably be a good benefit from a mediation between Mr. Saenz Flores and my client, his insurer, Progressive Judge.
So I'm going to put two things out there. As you all have been speaking, I am looking at the things that were most recently filed. And so I don't see a motion for continuance. If that's what you're asking for, Mr. McElroy, and it's agreed, please file it. If there's an agreement there, great, we'll get it reset. If you don't want it reset, if you want the continuance, but you don't want it reset for trial immediately and want like a 60 or 90-day window to go to mediation, 2022, I'm okay doing that. But we could just set it for trial and you'll have your deadline to mediate. So.
And Your Honor, we will be entering a new scheduling order. I'm taking it that Mr. Jessup does consent to a continuance, and we can get that. Yeah, we can get that on the record with you so that you can just sign it perfunctorily when I file it tomorrow.
Sounds good. What I will set then is 2 weeks out, anticipating this is getting moved 2 weeks out, put an entry of scheduling order. If you all will agree to whatever it is you're going to agree to, you can anticipate a trial date. I really don't want to put it that far out, but we're probably looking at end of August. Now that I have my 3-week July trial, and use maybe the 22nd of August as as a target.
We can work around that, Your Honor. I heard Mr. Rincon, and I heard that he's gonna tie you up for quite a while. So, you know, I know that the court has limitations and other cases, and sometimes you just have to go further out. Sometimes I'm happy with that. Sometimes I'm not, but it's probably practical because I think Mr. Jessup and I have worked together quite a bit. And I think if we can reach a mediated settlement in this case, I think we can probably get you off the hook. Although it's always better when you know you can resolve it more quickly if you don't resolve it at mediation. But
do you all think you can get to mediation within 90 days?
The problem I've been having lately, Your Honor, is Mitch Moss is booked for like 120 days right now. Okay. Judge Villa is technically, based on what he told me, he retired last week. But I think he's still got one of my cases where he owes me 2 hours of mediation. So I'm hoping that he gives it to me. Even though
you better catch him, Mr. McElroy. Hold on a second.
I know. So
hold on a second.
Yeah.
Myrna, what's going on? No,
I was just going to say that's a good week to 22nd of August.
Okay, beautiful. Yeah, I didn't want when I saw our camera turn on, I knew we had to hold up. Okay, so we're good for the 22nd. All right, then let's just do the entry of scheduling order, Mr. McElroy. If you'll get me email your motion, e-file your motion for continuance, agreed motion. I'll sign off on it. We'll get a new trial track. Okay.
And to give you a quick answer, Judge, we'll try to get to mediation as quickly as possible. You know, I know that there are some other mediators that, you know, we can opt into. Roger Davey, Joe Hood. There's, you know, the people at TAMS, Carl Green. So I'll discuss those with Mr. Jessup as well.
Okay. Please include your agreed to mediator on your scheduling order. Thank you very much.
Thanks, Judge.
Thank you, Your Honor. And we've excused.
You are. Thank you.
Thank you.
All right. Who's next?
Page 3, Judge. Calling cause number 2024 DCV 2447. Ventura Martin Rodriguez Venegas versus Mountain Star Constructors et al. Announcements, please.
Good morning, Your Honor. Ray Benavides for the plaintiff.
Morning.
Good morning, Judge Sergio Mendez on behalf of the EPPX and Foreman Maluli.
Okay, good morning. I'm sorry you all are here just on a scheduling status conference, unless you have, and you've been waiting 32 minutes or more.
It's okay.
My apologies.
No apologies
ready
needed.
For a trial date, or did you already resolve everything?
Just starting off.
Okay. I could ask, you know. All right. So you all are hearing the timetable. Generally, I'm going to go a year out, which does put us, you know, September, October, November, unless you all think it can be wrapped up sooner, but that's where the court is on their trial dates.
That sounds about right.
Okay, let's go, God, Myrna, you're reading my mind today. October 3rd, that's exactly what I saw. October 3rd, you all know the process, get the scheduling in order. You'll have your docket call that Wednesday, final civil pretrial a month before your mediation deadline. Anything outside of the date, please email us with your filed pleading and request your hearing, okay?
Very well.
Thank you,
Perfect.
gentlemen. If you don't have anything else, you are excused. Thank you for your time.
Thank you, Judge. You all have a great day.
You too. Bye-bye. All right, who's next?
Page 4, Judge. Calling cause number 2023 DCV 4215 Supply Network Inc. et al. Versus EP Integrated Fire Systems and Concepts LLC et al. Announcements, please.
Your Honor, James
David Lessman David Lessman on behalf of EP Integrated Fire Systems and Concepts.
Your Honor, this case actually was dismissed yesterday. We submitted an agreed motion to dismiss an order, and you signed it, and so I think you finally cleared this off your docket.
Thank you, gentlemen. Y'all are excused.
Thank you, Judge.
Have a good day.
You too.
Who's next? Miss.
Page 7, Judge. Calling cause number 2023 DCV 4075 Destiny Chaparro versus Manuel Delgadillo. Announcements, please.
Good morning, Judge. This is Sarah Said representing the plaintiff, Destiny Chaparro.
All right, let me look this one up. Bear with me. Okay, so we are set for a DWAP hearing today. I see a motion to retain was filed yesterday. We had a hearing, a status hearing on October 2nd. Yes, October 2nd. No one appeared for that hearing. That's why it was set for DWAP.
Yes, Judge. So we served the defendant on February 5th of this year. We haven't heard back from them. So we're just asking for extra time, 120 days, for the defendant to either answer or we will file for default.
But you served them back in February and I'm still waiting on a default?
It should have been filed this morning and we will probably file for default.
Yeah. No, your motion to retain is, do you have anything else?
No, Judge.
Your motion to retain is denied. The case is dismissed for want of prosecution.
Okay, Judge. Thank you.
Thank you very much. Who's next?
Judge, page 3. Calling, my mistake, Judge. Page 7. Calling cause number 2023 DCV 3746 Cavalry SPV 1 LLC et al. Versus Belen Quesada. Announcements, please.
Good morning, Your Honor. Leonardo Ruiz on behalf of Plaintiff Cavalry SPV LLC.
All right, just to be clear, there's no one here on behalf of Belen Quesada. We haven't received any contacts from that individual. No, Mr.
No, Your Honor, and she was served.
Okay, Mr. Ruiz, you may proceed on your default.
Absolutely, Your Honor. So after defendant was served back in March of 2024, her answer was due on March 25th of this year, and it hasn't been filed to date. The plaintiff proceeded to file a motion for default judgment that includes everything by statute. It includes a military affidavit, Your Honor, a certificate of last known address. There's a business records affidavit with supporting the damages, Your Honor, and there's also a bill of sale showing the title of chain of title, Your Honor. And given all this, we're seeking a motion for default judgment with damages of $5,449.71.
Okay, I do see the motion for default, and I believe this was reset once because we were attempting or may have attempted, well, let me put it this way, didn't get notice out before notice was sent in some form since the last hearing, sir?
Yes, my understanding is it was.
Okay, so is your understanding based on a document that you can forward to the court? In other words, do we have some, I don't know, confirmation, USPS confirmation that it was either sent certified or some other manner since the last hearing?
Let me see. I do know that the court at the very least sent it, Your Honor. Let me see if there's anything on our end.
Myrna? Or Mr. Medina, do you see a notice to defendant in this case that we sent?
Yes, the court did send this notice on October 21st of 2024, Your Honor.
Okay, via what, e-file? Or did we mail, or did it go to an email? What happened?
It was e-filed. It was e-filed also to Javits Courts ABC Legal.
But not the defendant, Judge.
Thank you, Myrna. Yeah, okay. So did plaintiff send notice to the defendant?
See, I'm trying. Yes, Your Honor, it was sent. Notice of oral hearing, and this was sent on October 29th, 2024, Your Honor. And I am happy there is a filing on October 30th, 2024 that actually is our notice sent over to the plaintiff, Your Honor.
Okay, so we were last
Yeah,
set.
regularly.
We were last set. Okay, a notice of hearing, oral hearing.
Mm-hmm.
Via regular mail?
Yes, Your Honor.
It shows regular mail, Judge.
Yeah. Was anything returned? Was that the last known address of defendant?
Yes, Your Honor.
Okay. All right. Check something. So this matter was set for hearing. So all this information is wrong, right? So your notice of hearing, hold on a second, wrong one. Let me go to October 30th. Mr. Nunez, will you go check outside and see? It doesn't indicate that it was via Zoom.
Yes, ma'am.
Thank you. And Myrna, just so I'm clear, we haven't received any communication from Belen Casada, right?
No, ma'am, we have not.
Okay. Wait a minute, but this says it was mailed out on October 29th?
Yes, Your Honor.
Yeah. And we're about 7 days out. Yeah, okay. We're gonna reset this for 60 days unless she's outside. Please send the notice with sufficient time and in a verifiable form regarding the default hearing, okay?
Okay, and then reset in 60 days, please.
Okay, so that should give plenty of time for let's see, we're November 6th. We're gonna look at January 15th, if you need a date there. January 15th, 10:30 a.m.
10:30 a.m. Should we include the same Zoom, the same Zoom
It's
ID?
the same for every, yeah, we don't change our Zoom. So if you include all of that, send it out ASAP so that we have ample time to know whether it gets, I don't know, whether you get your mail back, anything like that. We should be good to go.
Okay, and I should tell them we should do return receipt requested.
Yes.
Okay, understood, Your Honor.
Thank you so much, Mr. Reese. Have a good day.
Thank you too. May I be excused?
You may. Or 215. Mr. Leffman, did you have another matter?
Yes, well, I think what happened, Your Honor, is that actually Mr. Fuel spoke on behalf of a matter that was called that he was not to speak on behalf of. I had two sets.
Yeah.
Mr. Fuels was dismissed and gone. The other one was supposed to be a default, but answers were entered on October 30th and 31st. So there's no.
Is anyone here? Okay, so that's what happened. You're right.
But
So
I didn't want to leave. I didn't want to interrupt the court, so I just waited.
Okay, so we need to correct that. Calling cause number 2023 DCV 4215, Supply Network Inc. versus EP Integrated Fire Systems. May I have announcements, please?
David Leffman on behalf of EP Integrated Fire Systems.
And I don't show that there is anyone here on behalf of Plaintiff Supply Network. So that the record is clear, we had a previous hearing with you, Mr. Leffman, but it was with a different attorney indicating a dismissal. That was not your case. That was cause number 2022 DCV 0195 that was dismissed. And so we have this scheduled for default today, but I'm wondering where plaintiff's counsel is.
Your Honor, I think they had. I recall an email being sent by someone on behalf of plaintiff's counsel requesting this be pulled from the docket. I don't know that anything was followed up on or otherwise. Two answers were filed on October 30th, and answers were filed by individuals October 30th, and on the 31st, the entity filed an answer. So there are answers on file. Perhaps he just presumed that it would be, since answers were filed, it would be passed.
Okay, you're correct, Mr. Leffman. I'm looking up. I did receive an email. The court did receive an email asking to cancel this default hearing, and we need to get you all a trial schedule. So, Myrna, is the scheduling conference already set? Let me go back now.
Yes, ma'am. It's scheduled November 20th.
Okay, all right. Mr. Leffman, my apologies for that confusion, but we do have that set for a scheduling conference so that we can get you all on a trial track. Thank you for your time. All right, I don't know if we lost him, but we're adjourned on that one.
I'm sorry. I'm still here. I don't know why my camera about halfway through this quit working. So I don't know. It's not the phone. It's not a equipment issue on my end, but it quit working.
Okay, so we have you scheduled for a scheduling conference so we can get a trial track with everybody here, okay? Again,
Thank you. Thank you, Your Honor.
For the confusion.
Not a problem. Thank you. Maybe I'd be excused.
You may. Thank you. Bye-bye. Yeah, I didn't catch that. Okay, who's next?
That's everything, Judge.
Okay, thank you. We can get off of YouTube, please.